You'll call another against Royal Wolverhampton NHS Trust. Polmear and another against Royal Cornwall Hospital NHS Trust, and purchase against Ahmed.
Yes, Mr. Marshall. Last lap.
My Lord, thank you very much for giving me the time yesterday, because it is helpful. What I propose to do this morning, with your permission, is not to revisit the question of what did Alcock decide, but to work upon the next stage, which is whatever Alcock may have decided, what is the right way forward. Yeah. And in so doing, I am not abandoning or weakening my submission in relation to what Alcock decided. Because, as I repeat, my submission there is that, looked at in the round, Alcock was in fact applying its control mechanisms to all secondary victim cases. But let's not revisit that. Let's move on to whether they were right to do so or not. Thereafter, I will look at the post-Alcock cases, but very, very briefly, and very, very briefly for this reason. The post-Alcock cases, save for two, did not consider the question of should the Alcock control mechanisms to apply to non-accident cases, and in what respect, if so, and why, if so. Waters, which has been referred to on a number of occasions, as I indicated, may be right, it may be wrong, but it wasn't investigated. It wasn't a point that was raised. And so my submission is it can't be helpful when you are looking at the question of what should the control mechanisms be in non-accident cases. Likewise, the other first instance decisions. They may go one way, they may go another way. White and Liddell, for example, is a case where the judge decided that the barrier coming down was the event, but there's not the reasoning, and that assists me, but there's not the reasoning in that case which will assist you in determining what the control mechanism should be in non-accident cases.
Which case was that? Sorry.
White and Liddell.
Is that in the bundle?
Yes, it is in the bundle. I will come to them, my Lord, but
right, sorry.
I suppose what I'm saying is I will come to them in the context of saying they're not actually going to be terribly helpful. The two cases that may be helpful are, of course, Novo, where the consideration was given to this issue, and the Court of Appeal view in this case that they could see no reason why there should be the control mechanism that I'm speaking of. So those are two potentially significant cases, but my submission is the others don't address the issue, whatever their decision may be on the particular facts. So I will address those cases, but in that context. So may I start by making a list, almost. What is in favour of the removal of the mechanism, or the control mechanism, that there has to be an accident, Mr. Tyak's case? What is in favour of Mr. Weir's case, that you remove that control mechanism, but you replace it with the mechanism that it must be the first manifestation of injury? What's in favour of that? The first argument in favour, I suppose, is that it gives rise to fairness to that claimant, in the sense that it provides that claimant with a claim which he or she would not otherwise have. That, of course, is always the case when one is looking at where a boundary there will always be cases where an individual claimant will say, I am told I am on the wrong side of the line, it's not fair. And so my submission is actually pointing to the facts of the case and making it clear how distressing those facts are and how one would want in some way, some moral way, to provide for that claimant isn't actually helpful. And so actually saying it's not fair to my client isn't actually helpful. The other and wider reason why it's not helpful is because one cannot and does not look simply at the fairness or otherwise that the individual claimant may feel. One has to look at that case in the context of other categories of cases where there may not be recoverability. And it's the point I made in answer to my Lord Legate yesterday on a couple of occasions. One does not simply look at the fairness as between defendant and claimant. One looks at the fairness as between categories of claimants. And so if one says, well, let's move the boundary, one has to do so in the context of this case, in the knowledge that there are other categories of claimant who may likewise regard themselves as experienced distressing factual situations caused by a defendant who cannot recover. And it has to be in that context. And the example that can be given, the easy example that can be given, is the situation which I think we adverted to yesterday. I have a heart condition that is not properly investigated. My doctor comes to me and says, you've got this heart condition, you may have a heart attack at any moment, and I actually have my wife with me at that moment. We leave the surgery together. I collapse with a heart attack on the street. She can't recover because it's not a sudden and unexpected event. She would say, that's not fair. And that will remain the situation, even if the submissions of the claimants in these cases are to be accepted.
Is this a sort of occupational hazard of drawing lines in the drawing arbitrary lines in the sand?
Yes, it's what Professor Stapleton in Restraint of Tort was saying in her article, that once you start saying there is a hard case, we want to find in favour of the claimant because in this case it seems fair, so we will make an exception. That's when arbitrary lines start being drawn, and that's when the anomalies start to develop. And I think I said yesterday, and I remain with this submission, if we had said there can be no secondary victim claims at all, it would be clear, it would be comprehensible, it would not give rise to anomaly, there would be a dividing line that was obvious. But once you start saying, oh, well, you can have a secondary victim claim in these circumstances, then you immediately present yourself with the problem, well, how are we going to define these circumstances, and what does that do to people who are on the other side of the line? So the argument, it is not fair to me, has to be looked at in the context of, well, tort law does not compensate everybody anyway. Tort law does not compensate secondary victims generally. There is this exception that has developed. That exception has provided problems, being the arbitrary lines and where they are to be drawn, which is difficult to explain to clients is difficult to explain sometimes to defendants, and if we're going to be moving them backwards and forwards, is going to provide a high degree of uncertainty. And it will also throw up, every time you move the line, you are going to throw up a different anomaly or a different category of claimants who simply say, well, why am I suddenly on the wrong side of the line? So
the important thing is that the line is not arbitrary. I mean, my Lord Briggs is right that people will be on the wrong or the right side of arbitrary lines, but that's equally true of lines that are not arbitrary. So if it's a truly arbitrary line, then it's going to be extremely difficult to explain on a reasonable basis to the client why they're on the wrong side. But if there's an explanation for the line, however hard the result, it can be explained.
Exactly my point, my lord. So if I am saying to somebody, a client of mine, I am saying the law only provides for the primary victim, the person who has been directly injured, to recover. That's why, although you have suffered a physical or psychiatric injury or economic loss or whatever it may be, that's why you can't recover, because that's what the law does. The law says if you throw a stone into a pond, the ripples can go on forever, but the law draws a line, and that's where it draws it. That client may not like it, but that client understands it. But once you start making exceptions, it becomes more and more difficult to justify why the line is where it is. Particularly in circumstances that we've got to, in nervous shock claims. That is the central argument of Professor Stapleton in Restraint of Tort.
But that's an argument for not having any category existing at all. The point is, when you have got a category, you have to try and draw the line in a way that at least makes some sort of sense and is better than the proposed alternative.
Exactly so. And that's why, yes, she proposed you went back to the situation where you had no secondary victims. That is not, bluntly, a position that one could adopt now, and I don't adopt it. But it's why her argument against, for example, incrementalism is so important. Because once you have the line, you have to say to yourself, I am moving this for the benefit of this claimant, but what is it doing in relation to the categories of claimants? What is it doing in relation to the fairness as between defendant and claimant? And what is it doing in terms of certainty of the law and explicability of the law? And one has to look at those reasons. And that's why she and Lord Hoffman set their faces against, in this sphere, the idea that, oh, well, the common law develops by incrementalism, and therefore it's legitimate when a claimant comes along to say, well, incrementalism is the way forward, so we can move the line, because that's just an incremental move of the line. Incrementalism works in circumstances not where you are changing the law incrementally, but you are ensuring that novel factual situations are actually dealt with by the law. And as Professor Stapleton says, if you are using incrementalism from a starting point where you already have these arbitrary rules, at the very least, make sure that you're not making the situation worse. So, the first argument that may be put forward is this fair to the claimant? And I say, well, that's not actually the issue, because every claimant says, well, that's not fair to me. It's looking at the categories. It's looking at the fairness between claimant and defendant. And it necessarily encourages incrementalism, which is not to be regarded as a good thing that should be adopted whenever there's a hard case. Oh, we've got a difficult case. In that case, it would be very distressing not to find for the claimant, so let's have some incrementalism. That is not the way forward. And it's particularly not the way forward in circumstances where we're not looking at the general common law and how it can develop, but we're looking at an exception to the basic rule. And we're actually extending, or the suggestion is we extend the exception. The second...
I mean, it's fair to say, isn't it, that there are only two absolutely principled approaches. Either the Jane Stapleton, get rid of it altogether, or as you were describing, the Ben Heitner argument, it's just reasonable foreseeability. So we are in a middle area, whether we like it or not, and we've got to do the best we can.
Absolutely, and that's
within that area.
Absolutely right.
It might be said that we've got a line of decisions that have allowed psychiatric illness in medical negligence cases without examples of accidents, and therefore your argument might be said against you. Why are we going against where the law has already got to?
Well, I would accept that if A, there was a line of cases, there isn't, there's Waters, and B, it had actually been considered in Waters, which it wasn't.
So is your basic proposition that there are no non-accident cases that engender psychiatric illness claims by secondary victims?
No successful ones.
Sorry, your proposition is there is no reason why one should allow non-accident secondary victim psychiatric illness claims?
Correct.
None whatsoever.
I am going to list, I'm attempting to list the arguments against me, and then I'm going to list the reasons why my submission is correct, the positives and the negatives. And so the first argument against me I've already made. It's not fair to the individual claimant. The second argument that is raised against me is, well, what you're actually doing is creating an immunity for the NHS. That's the reality of what you're doing. And you shouldn't be doing that. And that is not itself fair. And that's the second argument that's raised. It's wrong, again, for two reasons. It comes from the problem, not from the position of this is an exception. You don't classify something as an immunity if you simply say the exception to the rule is not going to go that far. That doesn't create an immunity. This is not a situation where we are saying that there should be a class of primary victims, for example, who should not be able to recover. If I had been coming along and saying, the NHS are having a terrible time, my lords, my lady, and therefore what I am proposing is that you say that there should be no liability for negligence, save in certain constrained circumstances. That would be one thing, and it would be wrong. I am not saying that. I am saying, what is the pros and cons of moving the boundary as is suggested by the claimants? And the answer is, if you're moving the boundary of an exception or keeping the boundary where it is for an exception, that doesn't create an immunity for a class. That just means the normal law does not apply to that class, and it's not going to be, the extension isn't going to be extended. But there are other reasons. The immunity that is suggested is not actually an immunity, because, as I attempted to demonstrate yesterday, the distinction that we are drawing with accidents is the distinction between causing harm and not preventing harm. And that is a distinction that is a valid distinction because it is central to the way in which doctors work. and it is a moral position that is taken within the law of tort generally. It's nothing to do with acts and omissions, nothing to do with that at all. It's all to do with the question of, are you actually causing harm? And if you are actually causing harm to the primary victim, you can be taken, and it is right that the law should take the view that you are also responsible to people who suffer psychiatric injury as a consequence.
Well, Hippocrates is supposed to have said, first do no harm, and if the doctor breaks that principle, then they can be liable to a secondary victim for the consequence.
Yes. And therefore there is an underpinning of that it's not simply an arbitrary mechanism that I've brought out of the air for no particularly good reason. So there is a distinction, it's not an immunity, there is a distinction between accidents and these other events. Thirdly,
so you're saying that distinction of not causing harm and failing to prevent harm is the same distinction as accident and non-accident?
It's the justification for the distinction between accident and non-accident.
I can't help feeling it's going to lead to some very, very fine dividing lines. I mean, take where a doctor doesn't give the right medicine and also gives a little bit of the wrong medicine. You could say that not giving the right medicine is failing to prevent the harm, but giving the wrong medicine is causing it. But there may just be a decision as to which medicine to give.
My lord, that would be right, but it's answered by the point my lady made. Namely, I'm not suggesting that the line to be drawn or the control mechanism is, have you done harm or not? I'm saying that is the justification for saying that the distinction is accident or no accident. That the event that we're looking at, we know there has to be a qualifying event. That's the law. There has to be a qualifying event. Is the qualifying event simply going to be witnessing the death, injury, or imperilment of the primary victim, or is the qualifying event going to be circumstances where the death, injury, and imperilment was in the context of an accident? We always have to have the death, imperilment, and injury. Is it simply standalone, or is it within the context of an accident, which is what I'm saying? And the underpinning of that, the justification for that, is that there is a difference. There is a difference in feel, in principle, in ethical consideration as to whether one is causing harm or one is not. And that is not going to be the answer to whether something is or isn't an accident, but it's a reason for saying that actually this is quite a good control mechanism.
I mean, a major catastrophe could be caused by a failure to stop something which has started naturally.
Yes.
So would that be, which category does that come into?
That comes into the category if you have a major accident.
Yes, you get a gas leak, which is not caused by anyone, but the organisers failed to stop it when they should have done. What is that, an omission or a commission?
That's why, may I answer it in this way, my lord? That's why I'm specifically not saying we're looking at omissions and commissions.
Well, quite, I think it's a bit of a dead end, isn't it?
Yeah, but I agree. And I'm not looking at it in that context. I'm actually looking to say the test is accident or not accident, incident or not incident, event, external, etc. Yes. Is there a justification for that? Well, it's not the answer. Of course it's not the answer, but one justification is that there is a distinction that one can draw between somebody who is harming and somebody who is failing to prevent harm. In some circumstances, certainly.
But I think it's been put to you that you seem to be assimilating the two, that we've got accidents on the one hand which are concerned with causing harm, and non-accident cases on the other that are to do with failures to benefit or to prevent harm. And I think it's been put to you, they don't actually quite tie up.
But I agree, and I'm not assimilating. It's so important that I make the point.
Well, if they're not assimilating,
I'm just providing
how far does it take you?
I'm just providing a justification.
But if it doesn't work, because it doesn't tie up all the area, it's not a justification, as I understand it.
It works within the it works as one of the reasons. It's not the only reason.
So it'll work for some situations.
It helps justify in some situations.
But not all.
Not all.
So there can be cases of accidents where this is not a good justification.
There can be.
And there can be therefore other situations which are non-accidents where this doesn't help either.
And I see the point that my lord is making, but the mere fact that it doesn't deal with every situation doesn't mean that it's a bad argument. It's one of the factors that one takes into account in determining whether the distinction between accident and non-accident is workable and is explicable and is going to be understood by people who are going to be in this situation. It is one. It is not the only one. We're going to come to some others, but it is one.
As I understand it, you're making a point that the form of a rule doesn't necessarily correspond absolutely to an underlying rationale, that there may be other reasons why you want a brighter line than you would get from trying to map the underlying rationale, but that the core of the rationale may be something which allows you to look at formulating a rule broadly oriented to meeting that particular problem, but taking account of other considerations as well.
Well, I don't think I'm going to say any more on the point.
That is it.
That is it. That is it. We're still on the immunity point. That may be said against me. It is generally undesirable to have a class of defendant who is in a different situation by the way in which the rule operates from a class of defendant who is in a different situation. I hope I've dealt with that in the sense that I've said, well, there can be accidents within a clinical negligence context. But, again, going back to Professor Stapleton, actually, if there is a reason, a rationale for that event, which is an explicable and understandable rationale, then that's perfectly legitimate for tort law to take into account. One looks at the position not simply of the claimant, but of the defendant as well. And the NHS is in a different position to almost any other institution one can think of, in this sense. If I drive on the road, I drive on the road because that is what I wish to do. If I build an office block which falls down, I build the office block because I hope to make a profit, because it is part of a commercial enterprise. Within the NHS, of course, yes, we call it an assumption of responsibility to the primary victim, but the truth of it is the doctor has no choice about the matter. The doctor has to accept the patient walking through the door. And insofar as the suggested control mechanism that I put forward assists that doctor, there is a rationale behind it, namely that doctor is in a different position to almost anybody else you can think of who is conducting an activity, because they are conducting that activity because they wish to do so, because it is of benefit to them, because there is some commercial advantage to them.
I would have thought any public service is in the same position.
Like the police.
Yes.
Or the fire brigade, or whoever, but there can't be a distinction in this context between public and private provision.
No, I'm not making a distinction. I'm not making that as part of my submission at all. What I am saying is that there is, again, if we're looking at this in the context of are we creating an immunity? And insofar as we are, in practical terms, creating an immunity, can there be any justification for it? I am entitled to say that in these circumstances we are not talking about a defendant who is conducting an activity for their own benefit, who is conducting an activity for profit, etc., etc.
But these principles would apply to a doctor in private practice.
Yes, they would. They would.
So I'm slightly losing the thread of the point that you're making. Doctors in private practice are in it for profit.
Yes, they are.
You're not suggesting different rules apply to them, are you?
We must bear in mind that what I'm doing is I am suggesting, it is suggested by the claimants that this is creating an immunity for the NHS. I deny the fact that it's creating an immunity for the NHS, but insofar as it is beneficial to the NHS, that is not a reason for...
I mean, the short point is it's not an immunity because it's imposing a liability where one doesn't otherwise exist.
Well,
so, I mean,
and it's not treating...
terms, that's really the end of this argument, isn't it?
Well, my Lord, that was my primary submission, and if that's where my Lord thinks it should stop, then that's where I'll stop. Another advantage for the claimant might be said that the Law Commission suggested that there could be and should be a relaxation of the control mechanisms, and that in those circumstances you should look closely at what the Law Commission has said, because that might enable you to go down the direction of travel that they suggest. My answer to that is twofold. First, if the House of Lords in Alcock were not thinking of the situation we are talking about here, certainly neither was the Law Commission. They set out, I think it was a point made by my Lord Sales yesterday or the day before, namely the Law Commission set out what the current law was as they understood it, and they said there needs to be an accident. They put an accident in inverted commas. They didn't go on to define it further. And so
that was a question I asked on day one, and I'm not sure we've had an answer to what the Law Commission meant by the word accident.
The Law Commission didn't define it.
Didn't define it.
They left it in inverted commas. They did not go further to consider what sort of event would be the qualifying event. They simply said the law is that one must witness an accident. So I extrapolate from that if you reject my submissions that the Lords in Alcock were specifically considering the widest possible ambit of secondary victim law, then likewise there's no evidence at all that the Law Commission was itself considering this specific situation. I'm well aware of the fact that Lord Burrows could well say to me, well, sorry, but we did.
Well, yeah.
But if you did, there's no suggestion of it within the report.
I think if you go to the end of the report, you'll find a whole series of hypothetical situations set out. And I haven't now got them in my head, but I believe there would be examples of medical negligence within those hypothetical examples.
Of course. I'm not suggesting you didn't appreciate that there are medical negligence cases, but the specific question of what is meant by a qualifying event in these times isn't addressed.
No, but insofar as you're saying, one didn't think of situations where there was no external event, I think some of those hypotheticals might be put against you.
There is, I go back to the point, there is no discussion of whether in the context of a non-accident case the absence of accident should be regarded as a bar to the qualifying event, or, the absence of accident should be regarded as a bar to it being a qualifying event.
Well, of course you're right on that, it might be said against you, much as we were talking about Alcock. The counter-argument was because everybody thought it was blatantly obvious that there was no problem.
Well, my Lord, you'll forgive me for putting it this way, but you were making precisely that point against me yesterday on Alcock, and I make precisely that point today against you on the Law Commission. If you were thinking about it, you didn't say so. And if you weren't thinking about it, it seems a bit odd. But that's exactly what I say about Alcock. If the Lords were thinking about it, they didn't say so. I say because they didn't need to say so. But it's quite remarkable to think that they didn't have in mind at all clinical negligence cases. If you're with me on that argument, we go back to the fact that Alcock covers this situation. If you're against me and you say, and I can quite understand why it would be said, well, it's not clear, then we go back to the fact that Alcock is neutral, but so is the Law Commission. Against the proposition, even if one says, well, the Law Commission was saying that the control mechanisms can be relaxed, and they were thinking of that in the context of clinical negligence cases, and they just didn't expressly say so. If we come to that conclusion, and I hope it's understood that I say we shouldn't come to that conclusion, but if we do, set against that are the three House of Lords decisions that say you must approach the situation of secondary victims with caution. McLaughlin says it, confirmed in Alcock, confirmed in White. I don't have to take you to the references, they are throughout all three decisions. Proceed with caution. And insofar, and it's a submission I adverted to yesterday, insofar as you do proceed to look at incrementalism, insofar as you do, where is it? And even the Law Commission said this, my Lord Burrows will remember this. Incrementalism is of importance when medical science has moved on and makes a mockery of where we are in the law. It's Justice Windier saying the law marches behind medical science, limping slightly. When the law is marching too far behind medical science, it needs to catch up. And you can see that in those circumstances, there is a need to ensure that the link between what actually is the science and what actually is the law is maintained. But we're not talking about that here. We're not talking about there having been a brave new world of psychiatric injury discovery that impacts upon this question. This is a legal question and a legal question alone, namely, what is meant by legal proximity? Is legal proximity weakened to almost non-existence by the claimant's suggestion? And what are the policy reasons that exist in either having or not having the control mechanisms? And it's nothing to do with medical science. It's nothing to do with the advances that there have been.
Because it was always the case that there are people who, there are claimants, potential claimants who actually suffer psychiatric injury caused by the negligence of the defendant where they're not allowed to recover.
Yes.
It's not as if you're saying that it was thought that it was only accidents that ever caused psychiatric injury. It's always been known that there was much broader potential for suffering than that.
My lady has my point.
I think it's inherent in that citation we've been looking at from Lord Ackler,
Yes.
where he says, well, we haven't gone,
Yes.
the law hasn't gone there yet.
Yes.
There is some relevance, isn't there, in advances in medicine, because it would be absurd to say now that that injury is caused by a violent agitation of the nervous system.
Of course, but my point, my lord, is that in different cases where the claimant comes along and says, we've moved so far in psychiatric medicine that we actually have there has to be catch-up. Incrementalism may be a justification for the way forward, but that is not this case. It is not said by the claimant. There has been a change in medical science that justifies the position that we're taking.
And if they were, that would be something to be tested by quite a volume of expert evidence.
Yes.
I think.
Yes.
None of which we have.
But then, and you don't have it because they're not taking the point.
Exactly.
Yes.
It's not just that they're not taking the point. It's so that if they were taking the point, it would be an expert evidence heavy issue.
Yes. Because you would need to know the extent to which the medicine had moved on and how it impacts upon the particular circumstances of this case. So where you find in those three cases I mentioned, McLaughlin, Alcock and White, where you see examples given, and in the Law Commission, of, well, incrementalism is something that one must permit in some circumstances, my submission is, well, perhaps, but not here. That's not a...
There is a certain incrementalism in catch-up built into the Bonham test for negligence as well, because one might say, well, 10 years ago, it would have been perfectly acceptable not to prescribe that drug because it was not at all clear how it worked, or there were terrible side effects. But then 10 years later, you would say, well, no, medical science has developed so that an expert on the negligence point would say, yes, now it is a breach of duty not to have spotted that, not to have recommended that test, not to have prescribed that medicine. So there is that, I think, built into the negligence test as well.
That is true, but it is not relevant for the purposes of this case, either for me
I
or
understand
against.
that. I'm just...
And therefore, insofar as one might say, oh, is that a point I can take? I don't take it, because it clearly relates to the circumstances in which there is a breach of duty to the primary victim. And if there's no breach of duty to the primary victim, the secondary victim can't claim. Medical science's progress is reflected in whether there is in fact a breach of duty to the primary victim, and is already reflected, because the law moves there with medical science, but it's already reflected. My Lords, I've tried to set out against me what the factors are in favour of the claimant's extension, and to give the arguments to suggest that they're wrong. On the other side of the coin, however, there are real disadvantages to what is suggested. The first disadvantage, I think, became evident during my Lord, my Lady's questioning of Mr. Weir yesterday, or the day before, in that the proposal that he puts forward not only doesn't arise from Alcock, but is inherently unclear and uncertain. The idea that recovery will depend on the first manifestation of injury, and whether that was the shocking event or not, is particularly arbitrary, because it's not based on any underlying concept that is acceptable, but more particularly is inherently vague. What is meant by first manifestation of injury? How can one determine whether a manifestation of injury that was witnessed is going to be a qualifying event or is so insignificant that it can't be regarded as a qualifying event? Where is the line to be drawn in those circumstances? And the answer came back from Mr. Weir. It's going to be dependent upon the trial judge's view, using common sense, a close analysis of the facts, and a concept of fairness. Well, if ever that is an invitation not to settle claims, there it is. How can one, I ask rhetorically, how can one properly advise a claimant or a defendant in those circumstances where actually you're saying, well, we don't really know where what is meant by manifestation of injury. It could mean a variety of things. And we get to the stage of, and it could be one event or an elongation of events or several events. What's the answer? To which the client says, well, not only is what's the answer, but why on earth does it matter? And it becomes a bit difficult to justify why it matters. I'm not going to address that any further because actually, if Mr. Weir is right, and against myself in some respects, I say he's not right because it's a control mechanism that doesn't work. We have Mr. Tyak's position. Mr. Tyak's position is more principled, I suppose, easier, because he says, well, you just don't have to have anything other than the recognition or the witnessing of the imperilment, death, or injury. But the problem, as I said yesterday, the elephant in the room, as I said yesterday, was that Mr. Weir advances his control mechanism because he appreciates there's going to be an extension of claims and he knows that they need to be limited. Mr. Tyak rejects that because he says it's unprincipled, but thus has to accept that there's going to be an extension of claims. Now, an extension of claims per se is not a reason to reject the mechanism, and I do not suggest that is the case. But it is an extension of claims in circumstances where it is going to give rise to arguments about the horror of the event. And that is undesirable for all the reasons I said yesterday. Because if you remove my control mechanism, the only question then is, was the death, serious injury, or imperilment a horrifying event? And horrifying is something that has to be determined objectively and is a difficult concept.
Well, you have to ask that question even in an accident case.
But
in some cases it's blindingly obvious, but probably pretty rare. You have to ask that question. All that the extension does is move it, as it kicks the can down the road and requires you to ask is it a horrific question in relation to the death?
Two answers to that, my lord. The first is that, of course, there are going to be situations in which one can say, really, is this accident to be regarded as horrific? Of course, there are going to be those situations. But they are going to be fewer, because an accident necessarily brings with it the circumstance in which you are actually watching your loved one being crushed by a vehicle, being covered in blood at the scene, that sort of thing. A death from natural causes or an injury from natural causes, or even more difficult, imperilment from natural causes, doesn't necessarily bring that, and therefore the investigation is going to be necessary. And I'm not suggesting, my lord, and none of what I'm suggesting is, if you like, on its own, a factor that is going to destroy the argument to the claimants. But these are all factors that lead one to the conclusion there should be a control mechanism, and where is it going to be? So I'm suggesting that the extension of claims in these circumstances is not of itself desirable for that reason. The extension of the claims is not desirable because it underscores the difference between different categories of claimant. And to again utilise Professor Stapleton's point, it isn't actually asking the question, why are we helping this plaintiff? My control mechanism has these other advantages. One, it is a bright line. It is clear. There will be some cases where it may be difficult to say, well, is this to be regarded as an accident, an incident, or an a traumatic event external to the primary victim? But they are going to be relatively few and far between. The idea of an accident and what that involves is easily explicable to the ordinary person and actually is a relatively bright line. It means we can advise clients. It's a bright line because it enables defendants, on the basis of a relatively clear line, to dismiss a case without needing to go through the investigation, the determination of medical evidence, and a trial. It's a point my lady made on Tuesday, that actually, if you want, as is the overriding objective, to encourage settlement of cases, then the ability to say, there is no accident here, therefore this case cannot proceed, has its advantages. My Lord Briggs, it's not an answer to the whole question, but it is a factor that one has to put into the scales. Because that is the world in which we live now. The world in which we live is, let us encourage settlement. It is the cost of investigating these claims, and these claims are expensive. They're not road traffic accidents. They are expensive. Any claim that comes in, if my control mechanism doesn't exist, will lead to both sides having to get psychiatric evidence, both sides having to consider the impact of that psychiatric evidence, both sides getting expert evidence on the issue, and then going to trial or trying to reach a pragmatic solution on the knowledge that, well, this may go one way, it may go another way. If my control mechanism exists, in many, many more cases one is able to say, well, there is clearly no accident here, that is the end of the case. You don't have to go down that route. And that is the overriding objective. And that is a factor that supports the control mechanism that I suggest there should be.
That, I think, assumes that uncertainty as to outcome is antipathetic to settlement. I think there'd be quite a lot of people in the ADR industry who would doubt that.
Uncertainty produces pragmatic resolve. I agree. Pragmatism sometimes demands that there is going to be settlement. But actually, a bright line of there is not liability will mean that those cases don't have to go to...
They just don't get brought in the first place.
They don't get brought in the first place. They don't have to have the psychiatric evidence. They don't have to have the ADR.
No, I can understand that.
And my Lord, it is an important point, because actually those are consequences imposed upon a defendant, whether the defendant is right or wrong. Because if we don't have this control mechanism, the defendant is going to have to investigate every case, is going to have to get its evidence, and then, although the evidence may be clear, or perhaps give rise to a pragmatic settlement, that pragmatic settlement is going to, in large measure, be based upon the fact of, well, if we go to trial, it's going to cost us X anyway.
Is it this? You don't multiply uncertainties unless justice requires it.
My Lord, yes. And you particularly, may I put it this way as well, that is of itself an important point, but it's particularly important in the context of a situation where those uncertainties multiplied will be laid at the door of the defendant, whether the defendant is or is not eventually found to be correct. Because the defendant is going to have to pay for all these investigations, is going to have to pay for the expert evidence that is brought, is going to have to pay for the ADR, is then successful and recovers no costs because of quacks.
I mean, you are using the term accident as synonymous with event external to the primary victim. I mean, some people might say that the word accident is actually broader than that and would include any mishap that's unexpected, and would not go on, I think, to talk about external events. But it seems to me that your submissions do require us to take that more refined definition of accident.
My Lord, I think I have thought about this because, and I think I made the submission yesterday, that when Mr. Justice Old defined the position as an traumatic external event to the primary victim, I think the language that I used was that is an elegant way of describing a relatively vague concept, namely accident. And so I have at least considered, whether I've addressed it with my lords and my lady, I'm not sure, but I've at least considered, yes, can the term accident stroke incident be regarded as too vague? And if it is too vague, does that cause a problem? My submission is that in most cases it is self-evident that there will be perhaps some cases that there's a difficult dividing line. But actually, if you use Mr. Justice Old's definition, it becomes clear. Is that an answer to my Lord's point?
Yes, because if we're talking about clarity, I think people and lawyers need to know what the precise term means.
Yes.
And it would seem to me that because the word accident is a lay term and could cover the whole law of negligence, on one view, you are, I think, helping your case, if I might put it this way, by taking that more specific meaning.
Yes, and for the very reason that I've put forward, that I can see that accident incident brings with it a degree of uncertainty, and one wants to use an expression or a test that is as certain as possible.
It is actually quite interesting that the only time I've come across this is in relation to the New Zealand no-fault compensation scheme, which, as you probably know, takes out accidents from the law of tort. And I think it is right to say that they, in a sense, agonised about this, but ultimately came down in the legislation on a sort of test about externality to the person. I mean, I realise it's a different context, but I think it is, what your submission is consistent with that.
It is, I'm not going to pray it in aid, but I do say it is wholly consistent with it. And the difficulty with the no-fault scheme as applied to England, there were a number of difficulties, but one of which was, of course, it didn't deal with the difficult problem that many clinical negligence cases are not about breach, they're about causation. And that is a real area of difficulty which is not addressed by that scheme. But that's by the by. And that addresses the next point I was going to make, so I'll just say it rather than anything more, which is that I suggest that the control mechanism that I'm putting forward is workable. That's important, and that's why I think Mr. Tyack doesn't adopt Mr. Weir's position, because in essence, Mr. Tyack is saying the Paul consideration isn't really workable. And insofar as it is, it's very uncertain. This mechanism has with it a workability. My lords, my lady, the next issue, and I'm talking about advantages here for my control mechanism still, relates to whether it fixes any problems. I do not suggest that what I put forward fixes any of the other problems. They still remain. Likewise, however, the claimant's position doesn't fix any of the problems that there are with the anomalies. But what my control mechanism does do does not push us off into uncharted waters. In other words, there's the uncertainty of the principle itself, but there's also the uncertainty of the consequences. We don't really know, and indeed the Law Commission adverted to this. We don't really know how many cases there are out there. We don't know how many cases are as a result being settled pragmatically because we're not entirely sure of the law. We're not entirely sure of whether Mr. Weir is right when he says this is not much of a problem because, you know, it's incredibly difficult to get over the other control mechanisms. Well, he may assert that, but he asserts it on the basis of saying there's only been one decided case.
Well, once you accept, as you do, that having more claims isn't in itself a bad thing, I don't see that this is particularly irrelevant. Isn't it more important to focus on the additional problems that drawing the line differently would create, which one doesn't have to, one can identify what they are. You don't just have to say, oh, well, it might cause a difficulty. You can compare the sort of case that the redrawing of the line would allow with other cases that will not be allowed, and make the sort of point that Lord Dyson did in Taylor and Novo.
That's absolutely.
And that seems to me a much more significant point than saying, well, we don't know where it all might lead.
I'm not saying we don't know where it all might lead. What I'm saying is that it brings with it consequences that one might not have considered. And the example of that was the example we discussed yesterday, which is that a situation where the secondary victim is in the room with the doctor, or alternatively is not told about what the doctor has explained. Those are all matters that one might not actually have been thinking about, but they are factual situations that can exist. And then if they exist, where does that lead us? And at what cost? That's the only point that I'm making there. Yeah. I am conceding, accepting, that neither my mechanism nor the claimant's fixes the problems that exist. The question is, may they cause more problems? Yes, I've tried to deal with that. Do they lead to consequences that we're not actually addressing here today? They may do. If we have the accident control mechanism, we've actually lived with that for a long time. Here, we're moving the boundary, and we're having to deal with it again. So, in essence, my submission is that the control mechanism that I put forward accepts the view that there needs to be caution, accepts the view that there needs to be, that this should be viewed as an extension to an exception, keeps the link between claimant and defendant, has good policy reasons behind it because it is workable, it is clear, it can be explained, has some underpinning that allows us to say, well, there is a justification for that, and removes the problem of there being a move to the boundary which is viewed as incrementalism, which means that there's another raft of claimants who say, well, why not me? Let's move the barrier a little more. It accepts the fact that incrementalism of itself is not necessarily a good thing. It's simply a hard case, and is an explanation as to why the hard case results in success for a claimant. It removes any of that, and in those circumstances is much preferable to Mr. Weir's position. It is also preferable to what Mr. Tyack is saying, because Mr. Tyack is simply taking the brakes off in this particular area. My Lords, unless I can assist further on that topic, I'm going to leave it, and I'm going to move to the authorities. And I hope again I can deal with those authorities without going to the citations, because I think we've seen what they say, but let's see if we can. I say that the only function of looking at the post-Alcock decisions is either to see whether the post-Alcock decisions support my submission that Alcock actually addressed this issue, or whether actually they reflect upon where the boundary should be drawn. That's the purpose of looking at them. There is no particular purpose for the Supreme Court to look at whether they are right or wrong on their facts. There is no particular benefit even in saying, oh, do we want to overrule that case or not? You will overrule that which you think is wrong, but what's important is, do they help shed light upon those two issues? I.e., my submission that Alcock did in fact address this, but more importantly for this morning's submissions, does it help determine where the line should be drawn? And if that's right, if that submission is right, then Waters, although relied upon by the claimant to a very large extent, is of no assistance at all. And it cannot be of assistance because the Court of Appeal, A, weren't invited to address what Alcock meant. They worked upon the assumption that the Alcock control mechanism of there needing to be an accident, well, they didn't even assume it. They didn't address whether it should or should not apply. And because they didn't address whether it should or should not apply, they didn't ask themselves the question, well, where should the boundary be? The only issue in Waters was, can we have a horrifying event that takes place over a number of hours or indeed days? So there is no analysis of the issue that you have to deal with, accepted as much by Lord Justice Ward. He actually says in terms, we don't have to look at the law in any detail. And as I said yesterday, Waters, on the decision that they were taking, the Court of Appeal may have been right, they may have been wrong, there are viewers about that. It's not relevant for today's purposes. And if that's the case, then all of the other cases which either do or don't follow Waters are likewise not addressing the issue that you have to address. The only cases that did address it really are Mr. Justice Old, as we've dealt with, and it's an obiter comment, it is an observation, but it may assist you in your determination because he provides quite a precise definition which is helpful. And so in that sense, it is a helpful case. The obiter comment of Lord Justice Gibson in Sion is A, obiter, B, made only by him, C, not endorsed by Lord Justice Staunton, and again was in the context of no argument as to where the line should be drawn or not. And the cases that follow on are all of the same ilk. Either the point is raised by the defendant, or, as in Shorter, the point is raised by the defendant, but not determined by the judge, because the judge can find against the claimant for a different reason. And therefore, even after novo, one can well understand why the courts were saying, well, there may be this case of novo which sits unhappily with Waters, but actually we can decide the case on a different basis, so we don't have to address it. So there is no reasoning there that assists. So Taylor helps because it gives the definition. Not Taylor. Yes, Taylor and Somerset assists because it gives the definition, or it helps with the definition. Novo assists because there was a clear acceptance that what mattered for the purposes of the event was not the consequences, but an event external to the primary victim. And there was a clear acceptance that that is what there was the qualifying event. And the justification that is put forward, it may be a limited justification, it may be of value, but the Master of the Rolls clearly considered that for there to be potentially years between, not the breach, as was said later, but between the accident and the eventual consequence, was something that would be undesirable. And it's undesirable for all of the reasons that we've indicated previously. There's a fluidity of claimant. You can't have a fixed category of claimant. It's impossible in the world of underwriting because, of course, you have the event, you have the... if you have an accident, you know that you're going to be liable as the underwriter for that, the consequences of that accident. You know the category of potential victim. It's fixed. But in circumstances where you don't yet know what the consequences are, because there may be many and varied victims in the course of time, how do you then assess the risk? And so the delay between the accident and the consequences of the accident is an important consideration in that, to that extent. And that's why Lord Dyson was effectively saying, that is undesirable. It's undesirable that you should have an accident, but the consequences are not fixed by that accident. The consequences are fixed by whatever happens thereafter. So he addressed the issue with full argument and came to that conclusion. And that may be helpful. If you accept his reasoning, it may be helpful.
Can I put to you, to hear what you'd say about it, an alternative view of the authorities? So, we've got Alcock, and that was in an accident context. People are then thinking, how exactly is this going to apply in the medical negligence sphere? And we first of all start off with Tredget, which becomes quite a significant decision, although it's a county court case, where there was recovery in relation to medical negligence. You then get the Court of Appeal in Sion with what might be thought influential comments made by Lord Justice Gibson about what had been said previously by Mr. Justice Old in the Taylor case. Then you carry on through to cases like Shorter, and there's another case that's probably slipped my mind in between, but you're leading up to Walters. Now, in the whole course of that, from 1994, nobody had suggested that you could not have psychiatric illness claims in standard medical negligence scenarios. And that Court of Appeal confirms that in Walters. So you've got that 20 years. It was only then, subsequently, you get a decision that's not a medical negligence case, which is novo, that has this problem if you've got an accident case with a split between the accident and a long time lag until death and injury. And now it comes to us in this line of cases that suddenly says, well, what are we going to do about medical negligence cases that have been here since 1994? So might it be said that what you're asking us to do is to wipe out an established body of law because of the application of an accident case which was novo?
So the answer, my lord, let's look at dates for a moment. The answer is, of course, that Walters was 2003 and Taylor was 2014. So at its highest, you have Court of Appeal acceptance that you can have the situation in 2003 with a decision that does not sit with it in 2004.
But it's running into Walters were other cases, as I've already indicated. They may have failed, but nobody was suggesting that it was anything to do with the fact that there was no accident in the medical negligence context. It had never been suggested. I mean, until these cases, had it ever been suggested that this was a problem?
Well, it was suggested, for example, in Shorter, that, and I know that Shorter came after Novo, but it was suggested in Shorter, in terms, this case is on all fours with Novo.
Right, okay. Before Novo, was it ever suggested? I'm sorry, I've got my...
No. I understand the point you're making. It's a perfectly good point. What, in fact, you're saying to me, my lord, as far as I understand it, is, well, there was settled law for a period of time. Everybody was working on that basis. So why should we change it now?
Well, I think what happened is you had Alcock, and then what people were trying to do was to apply Alcock analogously to other situations that were not accident situations. Now, you say that was completely misguided from day one because Alcock said you can't have non-accident psychiatric illness recovery by secondary victims. But I'm putting to you that that didn't seem to be the perception that was being followed through by the courts, because nobody in medical negligence cases, in these psychiatric illness cases, was saying you can't have it because there's no accident. They were saying you need the shock to the system. But that then, how do you translate Alcock, that requirement, into medical negligence? It's got to be the horrifying death. So it could be said that what you're asking us to do is to turn the clock back.
It could be said, and insofar as there had been... Oh, I've been provided with the answer. Let me start again. It could be said that I am putting the clock back, but the first argument against that proposition is that if I am right in the submissions that I am making now, it would mean that you are having to say, well, the law over the last 20-odd years or so, or however long it's been, is undesirable, but it is the law and we don't want to change it. And yes, of course you can say that. I mean, we are saying that in this case because there is this, the assertion, well, if we really wanted to do it, we would go back to reasonable foreseeability and reasonable foreseeability alone. But we're not doing that. So that's the first point. The second point is that in Taylor and Somerset, Mr. Justice Old's case, 1993, the point was taken. And so it's not as if you are able to say to me, Lord Burrows, well, there was a settled acceptance of what the law was in relation to this. That would be a more powerful point. But there wasn't an acceptance. What there was Mr. Justice Old in 1993 saying, well, I think there has to be an external traumatic event. Lord Justice Gibson saying, well, I don't think there needs to be.
Well,
Court of Appeal.
Court of Appeal, but obiter, not agreed by Lord Justice Staunton.
Well, it's agreed with by Lord Justice Waite.
He agrees with both judgments.
Correct. So you can't dismiss it as
No, I'm not dismissing
just Lord Justice Peter Gibson.
No, I'm not. I'm not dismissing it. What I'm saying is that it's not. It's a court of appeal. It's an observation, obiter, from a court of appeal judge that another court of appeal judge didn't agree with.
And it's also relevant, surely, that in Sion the argument was being run. It's page 294. Lord Justice Gibson is referring to the argument that's being presented, says he doesn't find it persuasive, but clearly the argument is being maintained.
And so my Lord Burroughs' point would be a stronger one if he were able to say there was a body of accepted law that you are now wishing to overturn. But it hasn't been accepted. It wasn't accepted before Novo, and it wasn't accepted after Novo. It's just that, as I've indicated before, defendants who are going to be sensible about these things, if they've got two arguments that they can put forward, and one looks to be a stronger one that doesn't need the determination of whether Novo's right or Waters is right, well, you put the argument that doesn't need that determination at the forefront. And the same for first instance judges. That's what Mrs. Justice Hallett did in White. So there isn't a body of law.
So you're saying that because these come up as strikeouts, no lawyer is going to advise their client, well, let's proceed to apply to strike out, and our best argument is what was actually meant in a House of Lords decision. Did it mean this or did it mean that? And ask the judge on a strikeout to decide what it actually meant, or should we rather take a point which is more amenable to that particular application?
The position, my lady, is that it has been appreciated, as I keep saying, that Novo and Waters don't sit well together, and that a time had to come when the point needed to be determined, and 3 cases were obtained to achieve that effect. And the reason that was being done was precisely because it was appreciated that there was not a body of law that settled the position, that there was a degree of uncertainty that existed. And insofar as it could be said against me, well, of course, Novo is not a clinical negligence decision. Lord Dyson was in fact looking at 2 clinical negligence decisions, Taylor, Mr. Justice Auld, and Waters, and choosing between them. And Lord Dyson decided that although in a personal injury context, that in the context of those 2 clinical negligence decisions, he preferred the case of Taylor, Lord Justice Auld.
I think you're entitled to make the point that the Court of Appeal thought here that the law was settled in your favour, and that it was the appellants who had to come to this court in order to get it changed.
Well, that was going to be a point I was going to address when I came on to this particular case. But of course, you're right that they said we don't like it, but this is the law, and so. And I'm not trying to suggest, my Lord Legate, I don't adopt full-heartedly what the point that you've just meant, because I accept that there were views the other way. There were views the other way. But for Lord Burroughs to say to me, well, one way of looking at this is that the whole world appreciated that claims could be brought in the clinical negligence context without there being an accident. They all accepted that, and so what you're actually asking me to do is turn the clock on 30 years. I don't accept that analysis.
Your thesis that they all chose to go down that the defending it on the basis of other control tests rather than your accident one which is why the point never gets taken in case after case, sits slightly uncomfortably with your submission that the great thing about there must be an accident control test is it's so simple and straightforward and doesn't involve any expert evidence.
No, the reason that it remained for a time and remains to this day a difficult area is because there are two Court of Appeal decisions that are difficult to reconcile with each other. That's the problem. And that's the problem for all litigants. And how that develops in the pragmatic settlement of cases is one thing. But I do resist the suggestion that this is a brand new point that has never been thought of since Alcock and will result in 30 years of established law being overturned. This is not the case. This has always been an issue that has sometimes under the surface, but has bubbled along under the surface. What is the correct way of looking at these cases? Is it the Novo way, which after all is 10 years ago, or is it the Taylor way, which was 1993, or is it the Waters way?
I mean, in fact, the uncertainty goes back before the Walters a novo contest, because it goes back to Taylor in 1993 and or Justice Gibson's comments in 1994.
Exactly. So it's been here, it's been with us.
That there's uncertainty about the rule. I think your point is, if the rule was established, it would confer a degree of certainty. But if there's uncertainty about the rule, it's going to be difficult to strike out.
And of course, you can make it more certain by finding against me. Of course you can do that, but there are consequences of doing that, and the consequences, as I have tried to demonstrate, outweigh any suggestion that it is a favourable step to take. I come to Paul itself, this case, Court of Appeal, because of course I have to take the fact that although my Lord Briggs is right, it was a decision that said, well, the law is what you say it is. I also have to accept that they said we didn't like it. And it is there, again, I hope I don't have to go to citation, because it's, I hope, by now become fairly clear, but I have made the point that in the Court of Appeal, one of the reasons why they may have taken against the defendant's position was that they misunderstood the defendant's case. The defendant's case, and indeed it appears that the claimants have, the defendant's case was set out by Mr. Justice Chamberlain at first instance. If you would like the citation, well, let's go to it. It's tab 21, page 341.
Is it paragraph 63? Or
paragraph 63. And do you have the section? It's about 6 lines down. Mr. Baggott was at pains to emphasise that he had not advanced this argument before the Master, was not advancing it before me. And what was that the allegedly negligent treatment is capable of constituting irrelevant evidence. It has never been the case that we have said the breach has to be witnessed. But if you come to the Master of the Rolls...
Well, sorry, just on that,
yes?
I mean, I have been slightly mystified by the passage in your case for this court, paragraph 30, page 261, which has been emphasised by your opponents, where it said proximity exists where the claimant witnesses the breach and immediate risk of injury.
Because, and I can see that was not a felicitatious form of words, but what was being dealt with there was that the accident, generally speaking, produces the coextensive breach and consequence all at the one time. But it is clear from the reported case in the Court of Appeal, but it's particularly clear from Mr. Justice Chamberlain's assertion what the defendant's case was. It doesn't much matter, save because the more important point is that Lord Dyson did the same, Sir Geoffrey Voss did the same thing in relation to what Lord Dyson was saying. That's much more important. So if one goes to Nova at 636, the justifications for the position that he was taking, 636 paragraph 30 letter H, it seems to me that if the judge is right, Miss Taylor would have been able to recover damages for psychiatric illness even if her mother's death had occurred months and possibly years after the accident, subject of course to proving causation. This suggests that the concept of proximity to a secondary victim cannot reasonably be stretched this far. So that's what Lord Dyson was saying. Sir Geoffrey Voss, in the Court of Appeal of this case, at 294G, it's tab 17, 294G, says Novo is binding authority for the proposition that no claim can be brought in respect of psychiatric injury caused by a separate horrific event removed in time from the original negligence, accident, or a first horrific event. In other words, incorporating within the concept removed in time from the breach. And Lord Justice Underhill at 313 justifies that conclusion.
Where are we looking at?
313, paragraph G. He says, against that background, and he's dealt with the background, the fair reading of paragraphs 29 and 30 of Lord Dyson's judgment seems to be that the ultimately decisive feature was simply that there had been an interval of time between the breach of duty, whether or not it occasioned any injury at the time, and the shocking event.
That's more obviously wrong than what Sir Geoffrey Voss said.
So Sir Geoffrey Voss was taking it at once saying this is what he was saying. Lord Justice Underhill says he actually used breach, though he's used the term accident. Now, my Lord, why do I make this? I'm sorry.
Just going back to Geoffrey Voss, what are you saying is wrong with that?
What I'm saying is wrong about that is he's eliding the concept of negligence, which in this context means breach. And he's saying what is necessary is that you need to witness the breach, the accident.
Sorry, I'm still looking at the wrong paragraph. I don't think he says that at all.
This is paragraph 12, isn't it?
Paragraph 12?
Of Sir Geoffrey Voss's judgment.
Well, he doesn't. He elides the two. I mean, he doesn't specify whether it's the negligence or the accident that matters. He just lumps them in together.
That's why I said that Lord Justice Underhill was more obviously wrong.
Lord Justice Underhill actually explains why he comes to that conclusion. The Master of the Rolls simply says, this is what the case has decided.
But actually, in Novo, was there any evidence, or was it stated as to when the stacking of the racks? We don't know when the racks were stacked so that they fell down.
But the important thing, you're absolutely right, my lady, but the important thing, why is this important at all? It's important for this reason, that if one thinks that the Lord Dyson was suggesting that the important issue was that one had to witness the breach, it becomes understandable why the Court of Appeal says we don't like it.
Yeah, but I don't think they do mean that.
Isn't the important point at paragraph 76 of Sir Geoffrey Boss's judgment on page 308, where he identifies that the true question is how the authorities are to be applied in clinical negligence cases where there's a delay between the negligent act or omission and the horrifying event. That's where you can see him framing the question wrongly.
It's perhaps a better passage, yes, but it makes the same point. The only point I make is that insofar as you are influenced by the fact that the Court of Appeal in this case said we are bound but we don't like it, you have also to take into account that what they didn't like was not what Lord Dyson had said.
Yes, I mean, you haven't relied upon the statistical likelihood that the accident and the breach will probably be closer in time than, for example, the breach and the death, as a factor either supportive or adverse to the extension for which the others, your opponents are claiming. But if you maintain an accident exclusionary test, there must be an accident, there probably will be a much greater likelihood that that's proximate to the breach.
Yes, well,
there's some accidents that sit around like unexploded bombs before going off a great deal of time later, perhaps the falling of a building that's been badly designed.
but that's the problem, my lord, because
But most of them are likely
that's
to be
true.
coterminous.
What did the Court of Appeal focus on in this case? They were very focused on the fact, well, if an RSJ gives way, and the RSJ had been put up years before, and they were focused on that. And of course it looks mad to suggest, well, you have to, as a control mechanism, witness the breach, witness the house going up. Of course it looks to be a submission that is, at the best, difficult. And so it's not surprising they took against it. And so what I'm suggesting is that you gain no indication from the fact that they were unhappy with Novo, that in fact Novo is wrong, because they mischaracterised what Lord Dyson was saying.
So you say that they were taking it from Lord Justice Dyson that one must witness the breach of duty?
From Lord Dyson, they were taking the fact that they were assuming that what Lord Dyson was actually meaning was you have to witness the breach. And that's what Lord Justice Underhill says.
You can also pray and aid the fact that one of Sir Geoffrey Voss's headings makes the same assumption halfway down page 309.
My Lord Briggs, that's right.
And therefore everything that he's saying after that is
Yes.
under that heading. That's what he's looking at.
But particularly, I also, and I make the point again, I pray and aid what Lord Justice Underhill said, because he actually thinks about it and says, what I think Lord Dyson must mean is breach. And, bluntly, he's wrong. And therefore, I say that although the claimants might submit to you well, the Court of Appeal didn't like Novo. And that's one of the factors that you take into account in deciding whether Novo is rightly decided. I say that's not a good point. My Lord, what I've attempted to do is look at these cases in three ways, three sections. One, to ask what actually was decided in Alcock, and I've made the decisions about it. If I'm right, it doesn't end the case, but what it means is that if I'm right and you say it needs to be changed, you have to say that Alcock needs to be changed. I've then tried to look at the control mechanisms that are placed before you in this case, and look at the benefits and the drawbacks of those control mechanisms. I hope, from a relatively neutral position, looking for the benefits for the claimant and then dealing with them. I submit that both the positions taken by the claimants, both Mr. Weers and Mr. Tartt, for different reasons, are unclear, unworkable, and give rise to further anomalies and difficulties. I submit that the position put forward by the defendant, which is if Alcock did not consider whether accidents should be applied to clinical negligence situations, then the answer is that they should be, with perhaps the tightening of the definition that Mr. Justice Auld suggested. And I suggest that on the analysis of the cases, this has not been determined or considered before in any depth at all, except in Novo, or except in the Court of Appeal in this case, whereas there is the mischaracterisation. And I submit that where Lord Burrows put to me that I'm upsetting a settled position, I'm doing no such thing. Those are my submissions encapsulated in a couple of sentences. No doubt you would have hoped that I could have done that earlier. But those are my submissions. My lords, my lady, if there are any other issues I can deal with, I would be happy to do so.
No, thank you very much. It's nice of you. Now, who's going first?
I will withdraw.
Is that by agreement between you?
It's set out in the document.
Well, it may be, and I assume that means it was by agreement between you.
Now by
Perhaps historically one might have done it the other way around, but that's perfect.
I had asked for it to be done the other way around and bowed.
Okay.
Invited me to go first on the grounds that I'd asked to go first and was allowed to go first in my opening. Always compromises to be made, my lord, even in law.
Okay.
Can I start by simply dealing with the issue of the Law Commission report my Lord Richards invited me to address the court in relation to, which I'll do now as a freestanding short issue. If the court kindly goes to page 1812. 1812. At 2.28, this is the closest we get, if you like, to, I don't know if you want to call it a definition or anyway a description of the term accident. So the court will see, 2.28, the plaintiff must be close to the accident, both in terms of time and space. The accident includes not only the scene of the event which causes a death, injury or impairment, but also its immediate aftermath. So that I think is closest we get. In terms of what else relevantly the Law Commission report does, exactly as per the recollection of my Lord Burrows, first of all, there is criticism of Taylor and Somerset for taking an unduly restrictive approach in relation to the aftermath, without ever suggesting that there was a prior barrier established by Taylor, or indeed Alcock, to recovery in clinical negligence cases. I haven't put that reference in my note, but I should be able to find it quite quickly. Yes, if you kindly go to page 1877, 6.12, there you see the criticism of the Taylor and Somerset Health Authority decision on the basis that it was described as, we believe, unduly restrictive, and that's in relation to the aftermath principle. So exactly as per the recollection of my Lord Burrows, essentially there's never an indication in the report that their understanding of the state of the law per Alcock and or Taylor and Somerset is that there is a prior barrier to recovery. And again, consistently with the recollection of my Lord Burrows, it then followed, if you kindly go to page 1897, some examples given by the Law Commission following the proposed reforms of how, in different circumstances, claimants would recover, including C 6.61 in the middle, including in a clinical negligence setting. So I'm there on page 1897. So I hope that addresses my Lord Richard's queries in relation to the Law Commission report. I now go on to make my substantive submissions, and we have, I'm afraid, fired off some more PDFs. It's very easy for us to fire them off, so it's easily done, but unfortunately you then get overloaded, I know, and apologise. With more authorities, single PDFs at the moment, we can group them together and send you a sort of a group one, but it may be that you've marked up your single PDFs of previous cases that have come, so it may not actually be helpful to you. But if you ask us to, of course, we'll do that. We're going to make, subject to the court's approval, submissions under 7 headings as follows. The first is the ratio of the House of Lords in Alcock did not provide an answer to the question before this court. The second is the guidance in Alcock relevant to this appeal can be identified and can be applied. The court is looking for an event of injury which was reasonably within the contemplation of the defendant doctors at the time of their silent breach of duty. And I'll deal with the continuing misdescription of our case, including by my learned friend today, orally. Thirdly, the respondent's recognition of when a duty of care is owed to a secondary victim. In the case of the careless infliction of damage, that was the example given yesterday, provides further support for our case, namely that it was reasonably in the contemplation of the doctors who failed to diagnose and treat the primary victim that he might thereby suffer cardiac arrest, which could be witnessed by one or more close family members and be a shocking experience so as to qualify. I'll develop that. Sorry about it being a long heading for a third point. Fourthly, there is no need for a traumatic event external to the primary victim. Fifthly, and I do need to repeat this, there is no need for the secondary victim to have been a witness to the breach of duty. I know we've heard again today, orally. My learned friend distancing himself from that, but I will go back to that in short order. Sixthly, nothing turns on whether the defendant has committed an act or omitted to act, provided that the defendant breached its duty to the primary stroke secondary victim. Although my learned friend doesn't say that's the test he's now landed on, he says that's something like that lies beneath, but it's clearly an issue which has been exercised in the court for some time, and I propose to address it head-on regardless. Seventhly and finally, there are no cogent legal policy reasons provided by the respondent to encourage this court to row back from the application of Alcock in a clinical negligence setting, a step the courts have already taken, and good reasons to support the appellant's case. So can I start with Alcock? The ratio in Alcock was bounded by the issues raised by the parties. Can I kindly invite the court, please, to go to our written case, page 134. Page 134, paragraph 26, and I'm going to end up inviting the court to go para 26 to para 31, so just over the page. So we've sought to set out there the passage, so you don't have to go to it, and you've also got the reference, the Lord Ackner's opinion, in which he set out what it was that the plaintiffs were saying the law should reflect. And we have the two helpful summaries of what the case decided from Lords Steyn and Hoffman, if you go over to paragraph 29. And so again, you've got the references there, so I won't rehearse that. So there were three issues. Do you need close ties of love and affection? Do you have to be present at the scene? And does it have to be caused by direct perception? And just pausing there, all the cases up to Alcock, as I think is now completely common ground, had involved accidents, and indeed Alcock itself, seen by Lord Briggs, as possibly the largest tragedy to be litigated through the civil courts. And can I then emphasise that this case does not involve an accident. It involves the following: no accident, no traumatic event external to the primary victim, a silent breach of duty, delay, a silent accrual of the primary victim's cause of action, delay, then the manifestation of the injury, which it was the defendant's duty to avoid. And on the facts of this case, that was the first manifestation of damage, the cardiac arrest. And just again, before I go back to those three issues, just as a matter of principle, the House of Lords did not have the authority to fix subsequent courts, subject only to the application of the practice direction, with a rigid test extending beyond the bounds of the ratio of its decision, which did not address this issue with the court. It can't do it. We are, and I tread very carefully, but we are, in my respectful submission, in an area rather like Carnham Meadows, in which I respectfully side entirely with my Lords, Lord Burrows and Beggett. There was simply no basis for the court, other than by way of observation, in a completely non-binding way, to set out this is our view of the law of negligence. It was a case about the scope of the duty of care, a conventional case about the scope of the duty of care. Now that's an extreme example, because there, my Lord Sales will forgive me for making these submissions, I'm sure, but in my respectful submission, the court can make observations, but they're not binding, because they go so far beyond the scope of the issue before the Supreme Court in Carnham Meadows, and the same sort of principle applies here. In any event, in relation to those three issues, which I've just sought to identify, the first one, my learned friend Mr. Maskery accepts. The House of Lords adopted a flexible test in relation to close ties of love and affection. And I gave you quotes from the judgments of Lords Oliver, Keith and Ackner, but since we tend to focus on Lord Oliver, that was, for reference again, 578B to C, where we went as far as to say possibly even bystanders will qualify. And in relation to the other two issues, I think my learned friend accepted there was flexibility in relation to one, and I'm not sure we ever had an answer to the other one. But the position is, and we can just very briefly go back to Lord Oliver at 579 F to G. This is the language which my learned friend has been employing. 579 F to G. We're in the speech of Lord Oliver. in which he says, I equally believe that further pragmatic extensions of the accepted concepts of what constitutes proximity must be approached with the greatest caution. That was the cautious pragmatic extension submission. And that's what he says. In other words, even in relation to the three issues that were front and centre before the House of Lords, the House of Lords was not dogmatic. It was not rigid. It said the claims before it couldn't succeed for the reasons it gave. So, for instance, in relation to television, it said it can be the case that closed-circuit television, witnessing it throughout via closed-circuit television, may qualify, but not in this case. One of the reasons, as the court recalled, is that the rules in relation to what you can show on television limit what is shown to non-horrifying events. So even in relation to the three issues, there was flexibility. And as recognised pretty soon after in W and Essex by Lord Slynn, and I'll just give you the reference of the page, 648, the House of Lords was free to continue to develop the law flexibly in response to new factual situations. The learned firm was then confronted with what I think was described as the wrinkle that was a tire in British Gas, and my Lady Rose said, are you saying that that's a primary victim case? And he said, absolutely, so as to dispose of it. And if the court can kindly go to page 789. 789. We're in the judgment of Lord Justice Kingham, as he then was, between F and G in the second paragraph. Her claim is accordingly one for what the authorities in the literature have called damages for nervous shock. And if you go over the page, does your Lordship see that between F and G? Mm-hmm. If you go over the page, please, to between A and B, although the plaintiff suffered injury in that her home and presumably her possessions were burned and damaged, it is not said that she was at any time in fear for her own personal safety or that of anyone else. So she was not, on any view, a primary victim. And the reference that this was a nervous shock case from Lord Justice Wolfe, see then was, is at 785H. And from Lord Justice Dillon at 782C. So that was 785H and 782C. Another issue which was raised by the court. She's not a secondary victim either, because she wasn't in fear for anybody else's case. It was a novel situation. It was expressly recognised by the court.
Didn't they say somewhere, I may not have picked up, that they were going to try and apply the law by analogy to the secondary victim cases?
It's described as a nervous shock case, albeit, as my Lady Rose says, there was no one in the house. So it was, if you like, upset over damage to property as opposed to upset over damage to person. That was the novelty.
Yeah, no, sorry, I realise it's a psychiatric illness case, but didn't they say we ought to be thinking about the secondary victim principle?
Yes, my lord.
By analogy. So it's as if your house is like the primary victim.
Yes, my lord. That's the effect of how that's what it led to. And I think my learned friend Mr. Pitcher's put in his written case, careful that you don't end up protecting property over person. Yeah. It's by summary, but that's the effect of it. Mm. And just while we're on this, the court also raised the issue of contributory negligence, and rightly, in my respectful submission, through either having read through or that's in the bundle or through judicial instinct, recognised that contributory negligence should not carry over to the secondary victim. What we have is Clark and Linsell on this at 2049. I'll probably just leave you with the reference. And also the Law Commission report at paragraph 5.39, which is page 1866. 1866. So in circumstances where the House of Lords adopted a flexible approach to the issues it did address, where it did not address as part of its ratio the issue before this court, there can be, respectfully, no substance in the submission that this court somehow has to depart from Alcock in order to find for the appellants. And here we echo the observations of my Lord Richards to the effect that the exercise in inference drawing from certain passages in the Alcock judgment, as undertaken yesterday, was not productive. So we are, as we submitted on Tuesday, inviting the court to apply, or if necessary, refine the core guidance in Alcock to a different situation. That's our case. The second issue is the guidance in Alcock relevant to this appeal. The court is looking for an event of injury which was reasonably within the contemplation of the doctors at the time of their silent breach of duty. Just pausing there, what's notable from my learned friend's submissions is a rowback, a complete rowback, from what was a core submission they used to make, Court of Appeal and below, which was, this is all about legal proximity. It's all about legal proximity. You've got to understand the reasonable contemplation. Instead, we move into, this is a nice bright line rule, and soft features or factors prayed in aid at great length. Very soft factors, easier to settle, possibly. A little bit easier here, we think, and so on and so forth. But if we go back to the core points to come out of Alcock, they were as follows. First, the need to establish legal proximity from, and here I quote again from Lord Oliver, and this is page 573, if you can kindly turn it up. Five 7.3 D2E. From the combination of circumstances. So you see, he says, the answer, as it seems to me to be found, so sorry if I've rushed, it's page 573, my Lord, well, D to E. The answer, as it seems to me to be found. The existence of a combination of circumstances from which the necessary degree of proximity between the plaintiff and the defendant can be deduced. And secondly, how the law seeks to provide a remedy within bounds to, and here again I'm going to quote, so if you go kindly back to 569E, 569E is not cherry picking, this is identifying the key guidance. 569E, the court the core point is how the law seeks to provide a remedy within bounds to the passive and unwilling witness of injury to others. And again, if you go to 572H, that is, you see how he says an exception has arisen, and now he identifies that this is the law, this is the position, because he says that such an exception exists, is now too well established. So what are we looking at? We're looking at those cases in which the event of injury to the primary victim has been actually witnessed by the plaintiff and the injury claimed is established as stemming from that fact. So putting those two core points together, there is a workable test to control this aspect of secondary victim claims. The court is looking for an event of injury, a witnessable event of injury, which was reasonably within the contemplation of the doctors at the time of their silent breach of duty. We have not said in the Supreme Court, we did in the Court of Appeal, and we learnt from the Court of Appeal judgment, and we did not say in the Supreme Court, the test is first manifestation, and yet repeatedly, and the only response that my learned friend chooses to make is to a case that he knows we are no longer promoting. It is not an additional control mechanism, again, though characterised as such by Mr. Maskery, because it is a description of the core guidance in Alcock. So we're seeking to draw out of Alcock necessary limitation to ensure that liability is properly confined to cases in which it can be sensibly said that there's a sufficiently close relationship between the defendant and the secondary victim. And the flexibility in the law, about which I made submissions on Tuesday, is the driver for the application of Alcock to this area. Alcock didn't determine this issue, but repeatedly, and I won't rehearse those endless references, it's transparent that the law is to be applied flexibly, in other words, to be applied now to this context. So the courts are not being invited, either by earlier judgments of this court, or by the Law Commission, or by the government having considered the Law Commission's reform, to keep the law in a rigid position based upon the happenstance of the facts of cases which had been decided by the courts by the time of 1992 when Alcock reached the House of Lords. That is not how the common law operates. It is based upon the application of principle to new facts. And can I again refer this court back to the very powerful and, in my respectful submission, up-to-date guidance of Lord Scarman and McLaughlin, the reference for which was page 607. The court recalled it was the whole of that page. Although issue was taken with it by my Lord Legate, I would respectfully invite the court to reflect upon that passage, because that is how the common law operates, has done and still does. I
recall, actually, you said, as you said it twice now, that what I took issue with was your reference to something Lord Bridge said.
Well, and I apologise, my Lord. It was probably it was a misunderstanding on my part.
I mean, Lord Scarman's statement is, in some principle, something I strongly agree with, which is the law is based on principle where possible and not on considerations of policy.
My Lord, yes.
Something he drew, I think, from Professor Ronald Dworkin, who then returned the compliment by referring to his judgment in McLaughlin and O'Brien in Law's Empire. It's a great statement of a great example of principle rather than policy being stated. So I'm not objecting to Lord Scarman's judgment.
I'm extremely grateful and pleased, my Lord, and it sounds like a passage with which your Lordship was already well familiar. So it doesn't mean the law in this area is somehow unregulated and a breeding ground for disagreement and litigation, and there will always be a full place for strikeout applications, and Sion was an early example of that, because Sion was the not immediate aftermath, but an elongated period, and that was back in 1994. But at the same time, the court still has to take a realistic view as to what constitutes the event, and we repeat our submissions that the good sense of the judge comes into multiple aspects of the law of negligence, and this is one of them. The third submission I was making, my lords and my lady, is the respondent's recognition of when a duty of care is owed to a secondary victim is entirely of a piece with our case. I have 2 points here. The first is, Mr. Maskery recognised that a secondary victim claim would stand when a doctor gave a patient too much of a drug, which as a result was harmful. This was his negligent infliction of damage example, and I hope I have got that right. That was my clear understanding of the example he gave, in which when he was questioned by the court, he confirmed absolutely there can be a secondary victim claim in that case. Now that means that the respondent recognises that a doctor, in giving too much of the wrong drug, reasonably has in his contemplation that the drug may harm the patient and may harm a close relative who is an unwilling witness of the harm to the patient. That must follow, because that's his example. In that case, how can it sensibly be said that the doctor would not have in her contemplation that a close relative might suffer psychiatric harm if the doctor gave water instead of medicine, or failed to give the necessary drug at all. These are details. The point is, once it's recognised the doctor has in her reasonable contemplation not just harm to the patient by the doctor's conduct, too much, too little, or the wrong drug, but also in her contemplation the secondary victim, and the secondary victim can suffer, then it's going to apply across the board. Further, how can it sensibly be said that it matters if the effect of the doctor's carelessness was not immediate, but took some time, either because the wrong drug was not expected to harm the patient immediately, or because the patient wouldn't be expected to suffer for some time due to not being prescribed the correct drug? It can easily happen. You fail to give them an anti-epileptic medication. It doesn't mean they're going to have a seizure there and then.
To identify the wrong drug as an accident, would you not have to build into that the relative is a witness to that and knows that it's the wrong drug?
Not at all, my Lord. Not.
Because that's the characteristic of an accident, that you see your relative being crushed to death. In the delivery room case, in the medical example, you're there and you witness the doctor harming the baby. I'm not sure whether just seeing the drug without realising that there's anything untoward could qualify as an accident. But it'd be another thing if you saw the doctor advancing with the syringe, knowing that it was the wrong drug, and you see that injected and the consequences of it.
Your Lordship is enlarging entirely upon the concession made by my learned friend in relation to that issue. None of that was part of his case.
No, but I'm suggesting to you that that's a more rational line to draw.
Well, my Lord, respectfully, what your Lordship is now doing is reinvesting in the breach of duty. And as we know, and that's why I have to come back to it, because it's that important, it was a later point to make.
I'm not reinvesting in it because I'm treating it as necessarily that there's an external traumatic event witnessed by the secondary victim. And the question is, what counts as an external traumatic event?
Your Lordship's position is respectfully more coherent than the position which has now been adopted by the Respondent, because this is part of the submission I'm making in respect of the concessions which have been made, because I think it was my point 4 was to try and comprehend how it is that they say in the one breath there needs to be an external traumatic event, and then say if you inject someone with too much of the right drug or the wrong drug and inflict them harm, this is a case in which a secondary victim is entitled to claim, which was...
I thought Mr. Maskery's hypothetical was, yes, they're injected in with the wrong drug. That may or may not be witnessed by the relative. But what then happens is that they have a horrible convulsion and goodness knows what
yes, that absolutely.
That's them, and that is the traumatic event of injury that is witnessed.
And how remarkably close to our case this all becomes. This concession takes us almost over. It's overlapping with our case, because what the court is now recognising is it's not the breach. So it's not the injection, so we can't be attaching anything to you need to be to there, because that's been resolved. A complete concession in relation to breach has been given. It does not matter, RSJ example, etc., etc. So there can't be anything to that. I'm now seeking to show, of course there can be some delay. There must be delay because it's been accepted. It's not a case that factors in the breach. You don't have to have breach contemporaneous with injury. So now you've got a breach, which was nothing of any import, other than in the sense of graphically, it was simply the injection. Then all you have, exactly as per my Lady Rose says, all you observes at that point is a graphic and horrifying injury to the primary victim witnessed by the secondary victim. And my learned friend has accepted that would qualify. And that's our case.
Yes, well, that can't be right. But
well, it can be right, my Lord.
The more... You can't... If you're going to have the accident line, part of the definition of an accident has to be something that the person witnessing it appreciates it's an accident. You can't have, as it were, them witnessing something which they don't know it's an accident, but then being able to recover, because it's all got to be related to the causation of the injury. So that can only be that they realise they're witnessing an accident. You can't have an invisible accident for this purpose. It makes no sense if you're going to have an accident test. I'm agreeing with you.
Yes, I'm just trying to sort of...
Yes.
Yes. Anyway, I'm pretty sure the court has the point of the submission that I've sought to make.
Well, sorry, I just want to push this. This was at the point of Mr. Maskery's argument, as I understand it, where he was seeking to accept that you can have accident medical negligence cases triggering liability for secondary victims.
Correct.
And what he was trying to do, as I understood it, was to set out that there can be, albeit perhaps exceptional or unusual, accidents that count. Now, what I think you're now saying is that once he accepts that there are those sorts of scenarios, he's on rather a difficult sliding slope, because
he slid, man.
You end up with either ludicrous distinctions between injections and non-injections, and you then have to accept that what is being witnessed has to be
injury,
the effect, rather than the accident.
It's the event of injury. It's all of a piece with Lord Oliver. What's witnessed there is the event of injury.
And I think what Lord Leggett may be putting to you is that probably wasn't a great concession to make.
Well, it depends. It's a great concession to make, because it was the right concession to make.
Well, I'm suggesting to you that whatever Mr. Maskery may have said in argument, the point, at least so far as I'm concerned, you need to address is the situation in which both the accident and the injury are all of a piece a shocking event.
My Lord, yes. I think that's my next heading was relating to the need for an external traumatic event. So the second point I was going to take from this is Mr. Maskery acknowledged that the underlying basis for finding an architect should be liable to a secondary victim, where years after the breach of duty the building or part of it collapses, was that if you asked the architect at the time of the breach who would they have in contemplation as being directly affected by their breach of duty, it would be any person who was in the building at the time it's going to collapse in the future, and any close relative of that person who witnessed the person being hurt when the building collapsed. In other words, he again accepted that there is a proper secondary victim claim that can be made against the architect who in 1998 designs the building that collapses in 2023. And of course, that's at a time when the secondary victim or the primary victim may not be born, and all of the issues, all of these soft factors which have been promoted before the court simply apply on that example. And it's a recognition, this is coming under a heading in relation to the whole reasonable contemplation. That's why I sought to develop from the concession that was made what the doctor would have in her reasonable contemplation. So he then sought to contrast, as essentially he's obliged to do for the purposes of his case, he then sought to contrast that with the clinical negligence setting. But that submission that he made was an echo of the submission I made orally. I made that submission orally. I tried to give you the example in relation to Alcock, and then I gave you the example in relation to Taylor, and I could have given you the architect. This idea that if you ask the employer, whenever the racking is stacked, it matters not, a day, a week, a year, 10 years earlier, if you ask that person at that time of breach, who do you reasonably have in contemplations might be hurt, it's common ground in that case that defendant has in their reasonable contemplation not just the person who's hit by the racking, but also there being a close relative nearby who suffers psychiatric injury as a result. So now when you seek to draw the contrast with our case, you don't get there. Because if you go back to our case, if you ask the doctor at the date of the breach in November 2012, doctor, you are here you are treating a patient. Hypothetically, let's just imagine you fail to diagnose this patient as having significant coronary artery disease. Who, asking as a lawyer, I mean, it's an odd question for doctors, but asking them as a lawyer, who would you have in your reasonable contemplation as being affected by this breach of duty? In exactly the same way as that example, the doctor would say, well, I'd have it in my reasonable expectation that this patient who's got undiagnosed and untreated serious coronary artery disease might suffer a cardiac arrest, and it might be witnessed by close family relatives. And that's our case. And that is absolutely square with the core guidance in Alcock that I've sought to draw out.
If I may say so, Mr. Weir, the way you're putting it, you seem to be confusing reasonable contemplation, and I'm not sure reasonable does qualify contemplation with reasonable foreseeability. What we're looking at here is whether there is a relationship with proximity.
I mean, it troubles me, we discussed this yesterday, but the court doesn't directly apply the Donoghue and Stevenson, should they have had them in their contemplation, legal proximity test. It goes round the houses in this case by the use of the control mechanisms which we have in Alcock. I'm sorry, I think we're asking the same question.
I think yesterday the observation was made from the court that it might be fairer to me to answer questions in turn. And may I just seek to answer the questions in turn? Can I just go to well, it's my bundle 3. If we just go to Donoghue and Stevenson, if you kindly go to page 924. Down towards the bottom, right? 5 lines up from the bottom, to page 924. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected. So respectfully, I have sought to set out accurately the legal proximity test, not the reasonable foreseeability test. That's my answer.
The point about the road accident cases is the general assumption that the persons that the driver driving on a road has in contemplation is other road users. End of. That's the general proposition on proximity in road accident cases. And that's why Alcock and that's why McLaughlin calls this an exception or an extension.
My lord, yes. But what? When we go back to it's in McLaughlin and it's in Alcock, Donoghue and Stevenson for a reason. They don't reference it without good reason. They reference it because when you go back, and I've given you this passage earlier, because Lord Oliver says, what's the answer? The answer is the combination of factors such as to give rise to the necessary degree of proximity. So you go back to asking this question because we know that question is answered at a higher level of generality before moving to the control mechanisms. We know it's answered, but we're now looking to identify what are the control mechanisms. So it's helpful at that point to go back to the higher level of generality because this is the court that's going to give us the control mechanisms and tell us what they are or were from Alcock, etc. So we do have to go back respectfully to the core question. And my learned friend correctly did that. It's exactly the submission he made, and I absolutely agreed with it. When he said, the reason, if you're trying to understand why is it that we're saying it's an accident, and park the whole issue about not accident omissions, but it's something else my learned friend says relies on it, as my Lord Borough says it doesn't even marry, so it's a non-starter, respectfully. The reason that we say Taylor and Novo is correctly decided is because if you ask that question of the employer, who do you reasonably have in contemplation might be effective? What the employer knows is, if you tell them at the date of the notional breach, you ask them this question, what they know is that racking might fall down. And so someone might get hurt, and if there's a close family member who witnesses it, that person can also recover. That's the essence of Alcock. And if you're then in a different situation with a doctor who has a patient and you ask them, I'm inviting you to answer this question. If, by the way, you fail to spot serious coronary artery disease, who should you, by parity of reasoning, have in your reasonable contemplation? The answer is straightforward, that this patient's going to suffer the consequence of that, namely cardiac arrest, and if that's witnessed by a close family member, that person is also in a legally proximate relationship. So that respect from the Lord is how I say that one does have to go back to the reasonable contemplation test in Donoghue and Stevenson.
Well, I think we need to come back to this again at 2 o'clock.